the next case to come before the court is in re P.M.H. Counsel, you'll have 15 minutes to present its arguments. You're the only one here presenting, so we don't need to discuss rebuttal time. The argument is being visually and audibly recorded to be posted online, so please keep your voice up and remain behind the podium. Do not use the name of the child in this case or any children. We have read your briefs and we're ready to begin.
Good morning, Your Honors. My name is Attorney Todd Cheek. I'm the attorney for the appellant, obviously. The appellant's name is Tara Hirschberger. She's the mother of the child in this case, P.M.H. And I know there's a number of assignments of error before the court, and I first just want to start off by saying what relief it is exactly that my client is looking for. And that is that at the best, she would like the decision of the trial court to be reversed, such that she is retained or maintained as the residential parent of the child. At the very least, my client is asking that the matter be remanded to the trial court for further proceedings, further evidence, which I can elaborate on in a moment, and that the hearing not be before the magistrate that ruled on the custody decision in the first place, who is Magistrate Rogers. And I'll explain that as well. This case, I'm sure you've read from the brief, originated from the Child Support Enforcement Agency and an agreement between mom and dad that dad would have certain visitation. And it's important to note, I believe, that the visitation order that was granted is couched in terms of residential parent and non-residential parent. The father was granted visitation pursuant to the Wayne County Juvenile Court's standard visitation order as the non-residential parent. So a year after this agreement was made in order, so the parties go to the Child Support Enforcement Agency, they agree on a visitation order, that order gets submitted to the judge of the trial court, it's approved, trial court order. 1 year later, approximately, the dad filed a motion to change custody. There are hearing notices that go out describing that there's hearings for the motion to change custody. The magistrate calls the case at the trial, and this is in the transcript. She calls the case saying, we're here on the motion to change custody. It was not until the magistrate's decision after this July 2018 trial that there's any reference to this being an initial custody determination case. All participants, as far as the record can tell, is that everyone thought this was a change of custody case, not an initial determination case. And as you know, it has a big impact on what the burden of proof is and the standard, because if it's a change of custody case, you look at 310904E, which has this presumption that custody should remain with the residential parent. So my client went into this hearing thinking that's the standard. And it appeared that even the court thought that should be the standard because they're calling the case as a change of custody case.
Counsel, when you're actually presenting evidence, both sides, did either attorney talk about a change of circumstances, a substantial change of circumstances or anything?
I personally was not there. I was not trial counsel.
Well,
so
in the transcript, actually.
Yes, I'm trying to reflect on that, which is rather voluminous, and I do not recall if anyone was using those words, change of circumstances. To answer your question, I can't recall that.
But it was raised in the objections.
Certainly was raised in the objections. And obviously the objections were overruled. What we're urging the court to do, obviously, what the relief requested, is to reverse the order, thereby maintaining mom as the residential parent. And here's how I think the Ninth District gets there. And that is, it's either the trial court applied the wrong standard, therefore it should be reversed, or at the very least, further evidence taken on this whole change of circumstances issue, which wasn't addressed. Or, if you look at, you may not be inclined to agree with me that it's a change of circumstances case. And if you don't, then I think we still look at the best interest, because that would be the next inquiry on whether dad should be the residential parent or not. So I think under either scenario, I think the case needs to come back to the trial court or just be reversed. And with regard to the change of circumstances case, I poured over looking for what's the definition of prior custody determination, because I think that's what we're looking for. Was this a prior custody determination where mom and dad agreed to a visitation order and it becomes an order of the court? I think it is. I think it's a custody determination. Now, the reason I think that stems initially from the UCCJEA. There's definitions within 3127.01b3. It defines what a child custody determination is. And it talks about that being an order that provides for legal custody, physical custody, parenting time, or visitation, but not the portion of an order relating to child support. What's important here, I stress the word "or" because it's written in the disjunctive. The UCCJEA, as far as I decipher, is calling the child custody determination an order that just simply deals with visitation, which is what happened here. I looked for case law, of course. I wasn't able to find anything in the 9th District. I found cases in the 2nd District and the 7th. Now, the most recent decision is this In Re SSLS. If you read the judge's ruling on my objections, you can see that's the decision upon which the trial court relies. Because in that case, the court was concerned that it was applying at the trial level a change of circumstances burden on the father, and the Court of Appeals did not think that would have been appropriate because there was an agreed upon visitation order from the child support agency. It just kind of originated the same way that this case did. And I can understand how the trial court would rely on that, because it seems to go in opposite of what my client believes should be the case. But I think what is important to derive from SSLS is that the Court of Appeals was saying that it would be prejudicial to that father in that case to apply the wrong standard of law to him, which is exactly what's happened to my client, the appellant. So the trial court felt it needed to be remanded for further proceedings in this SSLS case, because it would have been unfair to the dad to apply the wrong standard, which is exactly what happened with the mom in this case. But there's two other cases that address this question. This question is the trial court ruling upon a motion to change custody rather than an initial determination case? The other cases, there's two of them that I found. One of them is In Re Mentwick, which is cited in my brief. In that case, just like this one, there was a prior order of visitation that was agreed upon by the mom and dad, and the dad then later filed a motion to change custody. In Mentwick, they decided it was a change of custody case rather than an initial determination case because everyone seemed to be on the same page that mom was the residential parent and dad was not. That just reeks of the same chronology in the way that dad filed his motion to change custody in this case, and the court issued summons for a change of custody motion, and the court's call for the case of change of custody motion. I think it's the exact same thing.
So in that way, they were unmarried parents.
Correct.
There had been no prior anything. It was just what CSEA filed when they filed their child support report.
I'm not sure if it exactly originated from the Child Support Enforcement Agency, but I think it did. Would it make a difference? Was that your question? No, I don't think it would make a difference. Because the end result is there's an agreed upon court order. Whether it originated from the parties' agreement just privately or from the Child Support Enforcement Agency kind of pushing it along. Because what happened in this case is mom applies for child support, mom and dad show up at the Child Support Enforcement Agency, and the Child Support Enforcement Agency will approach the parents and say, hey, look, if you guys want to, you can agree on the standard visitation order. You don't have to, but if you want to, you can. And if the parties agree, the Child Support Enforcement Agency will add that to their child support order. So that's what happened in this case, obviously, you know that. I believe that's what happened in Netwick, but I don't think that distinction is meaningful, if I'm answering your question. I think if it's an order, it's an order, and anything thereafter is a reallocation of parental rights and responsibilities under 310904E.
Does it matter that the court hasn't heard anything about the circumstances of the child? When the parents agree at CSEA, they're going to agree there that we're going to do a shared parent, whatever. Is there any significance to the fact that that just gets filed and the court never hears any evidence of any kind about the circumstances of that child at that time?
No, I don't believe so. I don't believe so. And the reason I say that is I'm drawing on the other case I was going to get to, is this In Re A.N., in which they're deciding the same issue as a change of custody or as an initial determination, and they're saying that there was a de facto designation of the mom as a residential parent, because in this In Re A.N., there was an agreed order that went on giving father parenting time per that court's standard order. And interestingly, the mom was not even specifically designated as the residential parent. They call that a de facto designation of mom as the residential parent. I think this is the same. This case for the appellant here is exactly the same thing. You know, what's interesting is we don't know in A.N. what sort of language the standard order is couched in terms of, i.e. residential parent versus non-residential parent. We don't even know that, but they still call it a de facto designation. In this case, we do know Wayne County Juvenile Court standard order couches its order in terms of residential and non-residential parents. Now, I think the parties had an agreement. They're waiving the right to present evidence, waiving the right to have the court make findings. If they have an agreement, that's what happens, and it's a court order. So any changes to that, it has to be in a reallocation. I don't see how it can be observed any other way. So I'd like to move on to the second assignment of error, because I think I've made my point with the first. The second one, the second assignment of error has to do with whether the court abused its discretion or its decision, best interest finding was against the manifest weight of the evidence. On behalf of the appellant, she thinks it was abuse of discretion and against the manifest weight of the evidence. Because if you look at the magistrate's decision about this, going through these particular best interest factors, which I won't recite because you know them, but we have the trial court addresses the wishes of the parents, and the trial court and the magistrate's decision can be quoted as saying both parents wish to be named the residential parent, but that's not exactly the case. The dad was questioned what he wanted, and he said he just wanted to see his child when he's supposed to have her. It was only after there was some, if you look at the transcript, it appears like some coaxing or really, frankly, trying to pull this information out of the dad. And only after the magistrate inquired of him did he say something about being interested in custody.
Well, counsel, what was the motion you filed?
The motion you filed was the motion to change custody,
Right.
right?
So that's what he asked for to begin with. So why are we talking about coaxing from the magistrate?
Well, because when we're on the record, someone may file some motion and then later change their mind when they show up in court. I think that happens pretty routinely. They may say something, oh, well, I'd be satisfied with something less, or I want something less, even though that's what I filed for. So I think that's what happened here. Dad just said, really all I want is to see my child when I'm supposed to have her. So back to these factors, and this is where I think the court continues to make false findings of fact, is the next factor has to deal with the interaction of the parents with the child. And in the magistrate's decision reads that there was no indication the child has a poor relationship with the parents or others.
Counsel,
Yes?
I have to tell you, your 15 minutes is up.
Thank you.
All right, court will take this matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on our website and that of the Supreme Court of Ohio. Thank you for your presentation.
Thank you.